You're listening to Wiley's Political Law Podcast, a series of podcasts on election law, ethics, and government investigations. In each podcast, attorneys at Wiley, a Washington, D.C. law firm, break down an aspect of the political law landscape with our unique insight into issues faced by our clients.
Welcome, everyone, to the podcast today. We're focusing today on a timely topic, which is the New Jersey pay-to-play laws. I'm Mark Renaud. I'm a partner in the election law and government ethics practice here at Wiley, and I have decades now of experience in helping contractors, government contractors, navigate the thorny issues of pay-to-play laws. For those who are not aware, pay-to-play laws are those rules and statutes and ordinances from state governments and localities that restrict or prohibit or require the reporting of contributions from contractors or potential contractors with those government entities. And often, and most importantly for our purposes, they capture contributions by officers or directors or other employees of those contractors or potential contractors and government officials. So what the pay-to-play laws are trying to do is to prevent the paying, which is making contributions, in order to play, which is receiving contracts. So the laws, some are better tailored than others, but the laws try to prevent, a contractor or a potential contractor from giving money to a person such as a mayor in order that the company or the entity can receive contracts from that, the city that the mayor runs. And of course, the same goes for not just corporate contributions, but it could apply to PAC contributions, or it could apply to contributions from directors or officers or other employees to the mayor, again, in order to get the contract with the city in that example. And these laws, are very widely across the states and localities. And of course, if you're in a financial services industry, you have a federal rule from the SEC or the MSRB or other federal agencies that may apply. But those who are not in the financial services area, it's the state and local laws that apply and that you have to watch out for. And these are also strict liability laws such that there's no intent necessary. So if you make an improper contribution to the mayor, in our example, you could lose the contract, or you could be barred from contracts with that city, or you could be fined or other things, even if you didn't mean to, and even if, it was your brother-in-law or sister-in-law that was running for the office or something to that effect. So we bring up New Jersey at this time because New Jersey in this year is one of the few jurisdictions that has elections. New York City also has elections, and they have pay-to-play laws as well. And there are a couple other jurisdictions around the country that have elections. But on the pay-to-play risk side, the focus is on New Jersey, especially with respect to the governor. Governor Murphy is running for re-election, and the rules apply with respect to any candidate for governor or lieutenant governor, but they're particularly pernicious if you make it to the sitting governor and then the sitting governor is re-elected, because the prohibition on state business can then extend through the term of the next governor. So that could be, 5 years, we count now, that the bar on business with a government agency in New Jersey could apply. So let's get down to the rule. The rule basically is for anybody who is a prospective state agency contractor in the state or is a current contractor. There is a limit of $300 per election that is applied to their contributions. And this includes the contributions of officers and their spouses and dependent children. And so if someone who's covered by the rule, and there are different rules for partnerships and people who own more than 10% of the stock, et cetera. But if someone makes a contribution that's in excess of $300 per election, then that can cause the loss of current contracts, and preclude new contracts being awarded. Now, that's the main state law, and that's the law that's particularly difficult to navigate, if you have a lot of employees in New Jersey and you have lots of New Jersey contracts. Also, every year there is a disclosure obligation, and that obligation is a little bit broader, and it's for entities that have $50,000 or more in business in the aggregate with any government entity, state or local, in the state. And that disclosure requires anybody who gave to pretty much any non-federal candidate or committee or party committee in the state, if they're a director or an officer or, certain stockholders, et cetera, partners, if you're a partnership, and their spouses and dependent children. If they gave over $300 per election to one of those candidates or per calendar year to a PAC or party committee, then those contributions are going to have to be disclosed. And that report was just filed, actually, for 2020 and on March the 30th. And so for 2021, it'll be due next March as well. Again, that's in addition to the gubernatorial prohibition. There are also a number of other prohibitions. I mean, the state agency prohibition also encompasses contributions to people other than just the governor or lieutenant governor or candidates for there. It also, basically you can't give more than $300 per year to state and county party committees, to legislative leadership committees, or municipal party committees. So party committees obviously are different than candidates. They raise money continually, not that candidates don't, but again, in an election year, they may be more active. Legislative leadership PACs may be more active in soliciting funds from, your officers or your more than 10% owners. And of course, corporate contributions are permitted, but the business entity itself that seeks a contract or holds a contract is still limited to these $300 limits. Party contributions can also implicate, the pay-to-play bans at the legislative level and then at the county level and the municipal level. So there's a whole panoply of different state laws that come into play with New Jersey campaign finance and procurement law. And then on top of that, investment advisors in the State Investment Council have their own rules, which are not $300 limits. They're different than the state law, and they're also different than the SEC MSRB rules. So that's something to keep into account. Finally, two more things, I guess. One is that one of the aspects of New Jersey's pay-to-play, besides having these prohibitions or limits, I mean, they are $300 limits. We refer to them as prohibitions just because that's how serious they are. In addition to, these prohibitions in the annual report, if you're bidding on a contract here in New Jersey or about to enter into a contract, then you're going to have pre-contract certifications and disclosures. So certain contributions from certain folks are going to have to be disclosed. And then part of the pre-contract certifications is that you're going to have to certify that you're not in violation of the pay-to-play rules for that jurisdiction. So a state agency, it would be with respect to the state agency law, and if it was a legislative agency, it would be with respect to that law, or county agency, et cetera. So it's another layer of potential risk and another layer of requirements under the pay-to-play laws for those who want to contract or are potential contractors. So finally, just to add to the craziness of New Jersey pay-to-play compliance, scores of localities in New Jersey have their own rules. Counties, boroughs, municipalities, and these, you can go to the Secretary of State's website, or you can go to the Election Law Enforcement Commission website, ELEC as we call it, and go to their pay-to-play page, and they have a link to what purports to be the various laws around the state, but our experience is those are not particularly current. But many of the jurisdictions in New Jersey use MuniCode to put their ordinances up online, although you got to make sure you check how they're updated, etc. But you'll see that these laws vary even more widely than the state, and they're quite strict. And they have a series of bans or limits or reporting obligations or all of the above. And they change from time to time. So the list that you find at ELEC's website or through ELEC's website is not necessarily the sum and substance of what those rules are now, or even the jurisdictions that have them. But if you have someone who's, hopefully if you're a government contractor, you have a pre-clearance process in place. Somebody wants to make a contribution in Newark, for example, then you're going to need to go to their website, look up what their code is. And I know that theirs changed last year, for example, and they made it even tougher. And some of these it's such Byzantine in what they've got there. I mean, I say it this way, this is not exactly one of the rules, but you can't, if you're a contractor, you can't, your people can't give to a committee that gives 35% or more of its funds to people running for the city council of a particular city. So, how are you supposed to do the math in that kind of situation? It's beyond me. Some of these are probably so broad or so vague that they're unconstitutional, but nobody's going to pay, a couple $100,000 for someone like us to challenge the constitutionality of those rules. So you either comply or you don't. So the minefields in New Jersey with respect to political contributions are unending. And so, after looking at that, what can contractors and government contractors do to protect themselves? One is that, they can implement a pre-clearance process whereby directors and officers and other employees have to pre-clear their contributions through compliance or through legal, and it's vetted against the rules. Second, you can, if you have a pre-clearance process, make sure it's up to date and make sure that you advertise it. And, people are more likely to do that when federal elections are taking place, even though the federal elections are rarely affected by these state and local pay-to-play laws. But you need to remember that in these off years, there are elections going on, and this year is particularly important to, remind people of their obligations under the corporate policy because of elections in New Jersey and New York City. And then finally, when you get those requests to make a contribution or to engage in fundraising activity, you make sure that you look at what the current law is in places, like I said, in the New Jersey localities, for example, there's so many of them and they change, every day almost, that, you're looking at the right law when you, in legal or compliance, decide whether someone's permitted to make a contribution or not, and whether, you need to file reports like the annual report due every year in March 30th in New Jersey. So with that, I hope this little talk about pay-to-play laws has been helpful. Please feel free to reach out to me if you have questions. Thanks very much.
Thank you for tuning in to the Wiley Political Law Podcast, brought to you by the attorneys at Wiley Ryan LLP. If you enjoyed this episode, we encourage you to follow us on SoundCloud. For additional resources and materials, head over to wiley.law. Thank you for listening. The views, information, or opinions expressed during episodes are solely those of the individuals involved and do not necessarily represent those of Wiley Ryan LLP and its employees. The material contained in this podcast is not intended to be and is not considered to be legal advice. Transmission is not intended to create and receipt does not establish an attorney-client relationship.